Monday, February 16th. It is Family Day. Hope you're enjoying the day. I'm taking a little break here from Fun and Games with the Fam to have our usual daily time together. I want to open up a series today talking about open meetings, closed meetings, public privacy, transparency, what the Local Governance Act says and stipulates, because council is entitled to some closed sessions and privacy, and the public, of course, you as a resident, are entitled to open meetings and transparency. But how much? How much is required? How much is demanded? How much is conceded by the council, et cetera, et cetera? So there are things to get into in that regard, and I want to briefly start today with the Local Governance Act. Ultimately, as I want to be doing, I want to be leading a council team that you can trust. And I think a lot of the emotion around the failings of council in St. Stephen in particular center around the feeling of residents, the feeling that council does not disclose what they're doing, does not communicate enough what is happening. That sense when you are a resident that you don't really know what decisions are being made, how they're being made, or even understand, am I entitled to X level of transparency and no openness? Does the council have to disclose things that they're not disclosing, etc.? So I'd really like to have that be clear in all our minds and decide what the minimum standard is and whether or not we want, as a municipality, to go above and beyond that. So the Local Governance Act, our favorite thing, hopefully you're getting the impression that any and all regulation really does flow from the Local Governance Act. That is the starting place. That is how the province, the provincial government, has regulated the activities, the standard operating procedure, the modus operandi of municipalities in the province, of course, of which the Municipal District of St. Stephen is one. Let me draw your attention to Part 6 of the Local Governance Act. If you have your own copy, page 63, well, Part 6 starts earlier on, but Part 6 is really all about council meetings. I've just got it here. That is the entire content of Part 6. It's called council meetings. And specifically, so there's things about, voting and decorum and how things are carried out. But we really get into the heart of the matter in terms of transparency with the public in Part 67 of Part 6. So Section 67 says, subject to subsection 68(1), which is upcoming, so you haven't missed anything yet, all regular and special meetings of a council shall be open to the public. All means all, except, of course, there's a caveat, because this is a legal document. And then B, all meetings of a committee of the council shall be open to the public. So meetings of a council and committee of a council. Now, we don't have a lot of committees in council here, but it is interesting to note that if council ever made a committee, that means a few members of the council meet on something, and some municipalities do this. A smaller group of the whole council is responsible for some portfolio, some service that they are overseeing, then those meetings must be open to the public as well, except in 10 cases, 10. And that's why I want to run these down real quick for you. And what I want to do when I read these, because here we are in the next section, 68(1) that I just referred to, this is called closed meetings. So 68(1) is about when council can have meetings in camera. So if you are familiar with council meetings, I've been going for a couple years now, after the regular council meeting or committee of the whole, council may say, we are now inviting the members of the public to leave the room because we are having a meeting in camera, a closed session. When are they allowed to do that? Now I'm bringing this up because the Local Governance Commission, which we mentioned yesterday in the last couple of days, I introduced a new party in our cast of characters when it comes to how municipalities run. The Local Governance Commission set up, it's an arm's length, it's legislated by the province, but it's an arm's length recommendation body and regulator. They basically said a lot of municipalities are operating outside of what they're allowed to in terms of the 10 stipulations. There are too many closed council meetings that are happening privately that don't meet the 10 stipulations. So These 10 stipulations are really important for, of course, a mayor and a council to know, the CAO to know, so that they don't run afoul of that and say, like many municipalities did apparently, and I'll maybe delve more into that tomorrow, about how, oh, well, you know, this is private. We need to keep this private. The public shouldn't know about this, or we're entitled to certain privacy around this. Well, not as often as they thought, apparently. So I want to read you the 10. But then while I'm reading them, just to keep you engaged and so you don't glaze over or think this is not important, pay attention to who is being protected by the 10 provisos, the 10 categories where meetings are allowed to be kept private, okay? And then we'll kind of maybe do a roundup of like who is being protected, who is allowed privacy according to this list of 10. Okay, so the first thing is number one, and I'm reading from 68.1a, page 64 in the Local Governance Act. The first one is information. So basically, let me just back up here. A council meeting or a committee of council meeting may be closed to the public for the duration of the discussion if it is necessary to discuss the following. So I wanted to read that so it makes sense. Necessary to discuss information of which the confidentiality is protected by law. So, and then it says, you know, if this act or any other act protects somebody's privacy, then it needs to be in council. That's kind of in camera. That means a secret meeting, a private meeting, not secret. that's the wrong word. It needs to, if it needs to protect somebody according to this act or another act, this is kind of a catch-all. But then it gets more specific, okay? So that protects kind of statutory rights or legal compliance, that kind of thing. But the next one, B, personal information as defined by RTIPA. Now, RTIPA, it links it here as the Right to Information and Protection of Privacy Act. You can read that whole act, but that's basically so our private information, you and me as residents of New Brunswick, is protected. And if somebody asked for emails or correspondence between municipalities or levels of government and your name came up, you want to be protected, right? And you can see something like the Epstein files right now, which is very relevant in our culture, in our social zeitgeist. You're seeing lots of names being exposed there. Protecting victims is important, but sometimes it's not victims. It's just like people being named back and forth and people being painted with a brush, maybe emails that they didn't want to be released, that kind of thing. So we don't want that kind of thing happening in municipal council meetings. And so if your information is protected as defined by RTIPA, that act, then that is one reason why if a council is about to meet where names like that will be exposed, they can have a private meeting. The next one is number 3, information that could cause financial loss or gain or jeopardize negotiations. So this is really important. The municipality is often in negotiations with capital developers or land transactions, real estate agents, maybe that kind of thing. And it's important that those negotiations be kept confidential because, of course, if you have third, fourth parties, names being spread around, it can raise rates. For example, if somebody was negotiating on a piece of land and that came out who the party was negotiating with, then maybe that party could be contacted or overbid, that kind of thing. Landowners around could coordinate raising their prices. So this is really designed to protect the municipality from unfair competition, and maybe the person in negotiation with the municipality as well from being sniped or lowballed or overbid or that kind of thing. So negotiations need to, in order for them to be maximally effective, that kind of thing needs to be kept confidential. The next one, proposed or pending acquisition or disposition of land. So again, the real estate example I just used specifically, land, the municipality needs a strong negotiating position if they want to purchase land or sell land or that kind of thing. And if that's widely public, then you'll have other speculators or other parties coming in and really mudding the waters. And that could end up meaning the taxpayer pays a lot more or loses out or that kind of thing. So the province long ago, and the Local Governance Act, it was ratified here in 2017, but this has been built in for a long time in terms of this kind of thing being confidential in meetings. The next one, confidential information from Canada or a province. So the federal or provincial governments need to be trusted in terms of their negotiations as well. So if something is being negotiated with a level of government, then it can be kept confidential. The next one, legal opinions or advice, solicitor-client privilege. So if the municipality, our corporation that we live in, for example, is a client of a lawyer in a lawsuit, then of course there is client solicitor privilege there, attorney-client privilege, and that, of course, does not need to be widely shared with the public. Things, of course, will run out their due process. Court cases are public, but in these early stages of meeting with the solicitor and that kind of thing, that can and should be kept private, according to the Local Governance Act. Litigation or potential litigation, so once again, lawsuits that may be coming up if you're not a client yet of a lawyer, but there are some litigation coming up. Then, of course, if this is about settlement strategy, preparing defense or that kind of thing, that it's very important, obviously, that be discussed in confidentiality because, a court case is by definition oppositional. Next one, security of buildings or systems. So if this one's pretty self-explanatory. If we're talking about codes or how to get into sensitive buildings, public works, assets, that kind of thing, where are the keys? What are the codes? Of course, those things should not be public, and that is a reason to go into private session. The next one, police investigation information. So again, when we need to protect victims or when you need to look at the confidential rights of even people who are accused or charged. Again, these things have their due process, but just in the context of a municipal council meeting, best to keep them confidential. Labor and employment matters. So this is where, as we've talked about the staff being protected, labor and employment, the employees maybe need bargaining when you're talking about salaries, things like that, negotiating agreements with staff and approving salaries. The CAO oversees a lot of that, but there will be discussion around personnel in that regard, and that needs to be confidential as well. Now, what did you notice from each of those things? Who was protected in the 10 things? Well, you had individual privacy, you had legal matters, you had negotiations, you had public safety, and you had kind of employment bargaining integrity. Those were the people and are the people who need to be protected by private meetings. But who is not protected by private meetings is the council. So that is kind of a really good principle to use, whether you're on council or the mayor or whether you're a resident. The council cannot go into private session to keep, communication secret because something might be controversial, to strategize around rolling out communication with the public, or just saying this could be a really sticky wicket. We want to keep it secret. No, that is not how that goes. Now, I want to delve more into the complaint process and how it protects all parties, whether it's a resident making the complaint or the mayor or councilor who's the recipient of a complaint. When the Local Governance Commission kind of blew the whistle on this and said, you shouldn't be having complaints in private meetings, well, there's a really good reason for that. But like I said, as I wrap up here, it's not about protecting the council. I want to lead a council you can trust. And what that means is following the stipulations, making sure any closed sessions meet the 10, but also making sure that we're not just having private meetings because we think something is controversial. In fact, that is when the public needs to be brought in. It is no doubt messier, but hey, when we work together, we can't be avoiding conflict together as a community. We need to be working together, sometimes having disagreement without being disagreeable, but that is how the best plans emerge for all of us and making sure everyone is taken care of and the common good is set before us, and that's the way we're making decisions. All right, so that is it. I hope you enjoy the rest of your Monday, and I will see you Tuesday, where we're going to talk more about the Local Governance Commission's decision around what was done and what council needs to think of in terms of making sure that you as residents are included fairly in decision making. All right, have a wonderful day, and for the rest of the day, take care of yourself, your neighbor, and let's build up St. Stephen. Cheers.